Tyler, I was going through my planning for my estate, and I just have a will. That should be good, right? That really depends, and there is a correct answer to that. And usually the correct answer is no, you need more. Here's why. What is a will? A will is a personal directive where you list how you want your assets to be distributed upon your death. Now, if you just have a will, they will be distributed in accordance with that. However, you will go through something called probate. What is probate? Probate is the legal process of proving the will. Anything can be a will. I can scribble down on some piece of paper right next to me what I want, sign it, and we're good. Then 10 days later, I can scribble down another will, sign it, we're good. Which of these is accurate? That's where the problem becomes. Even if there is only one will, it's got to go through probate, which is a part of the court system. On average, probate takes 6 to 18 months to get through. And that's just average, so it can be longer than that. And while your assets are going through probate, your assets are totally frozen. I often tell the story of my grandmother who did not have a trust, she just had a will, everything had to go through probate, and this was during the global financial crisis. She passed away in March of 2008. While everything was going through probate, we had no ability to sell or reposition the assets. We just had to watch as the account went down 40 to 50%. So the other aspect is with a will, they are very easy to contest. So if you leave someone out of the will, they can just contest and say, oh, they just made a mistake. I wasn't listed in there. And that's valid. It'll go through the court system. And then you end up with a situation where the court system can determine who, how, and when your assets are distributed. That's not the biggest problem, though. For some people it is, but there's also a massive fee. They value your estate. The entire estate that goes through probate is valued. Guess what? Does the government pay for valuation? No, you have to pay for that. The probate fee is 3%. But you got to be represented. It's in court. So there's an attorney. You got to pay the attorney a fee. So you have the probate fee, you have the attorney fee, you have to pay for valuation, and it takes 6 to 18 months. What often happens is when you pass away, your children or your beneficiaries, whomever they are, going to be grieving. We want a situation where they can grieve peacefully and not have to be going through this long, hard court fight while they are grieving. And then they get out the other end and a large chunk of your assets were taken by the government effectively because you didn't plan correctly. So a will can act as a personal directive, but even if it's a valid, good will, there's only one, and it's not contested, guess what? It's still going through probate. And so depending on the asset type, there are other ways to make sure they don't go through probate. So for instance, for houses, there is something called a ladybird deed. A ladybird deed exists in a number of states: Texas, Vermont, Michigan, West Virginia, Florida. There are similar variants in other states, which basically allows you to get what's called an enhanced life estate and have your children directly on the deed. They're not the owners of the property, though. That's important to say. So that when you pass away, your children are already on the deed. The house just goes to them. You didn't need a trust. You avoid probate. You're all good. You need to make sure any of your accounts, your IRAs, your 401ks, you need to make sure you have designated beneficiaries on all of those, or else those will go through probate. Same thing for non-qualified brokerage account. You need to have beneficiaries on there, or else it will go through probate. Now, where and why can a trust be important? A trust effectively allows you to smoothly handle this process because you can have all of these different asset types classified under one entity, this same trust. So we're talking about revocable grantor trusts here, so you can dissolve the trust at any time. If you set up this trust a year down the road, you decide, I don't want to do this, you can get rid of it. You're not locked into anything. But you can have your house in trust name, your brokerage accounts in trust name, and then if you wanted to, you could have the trust as the beneficiary on there. This way, everything goes through one vehicle and then it's distributed through the trust. And so that's oftentimes what people find to be beneficial is you have it through the trust. But what is also good and what's also important is there is a personal directive part of the trust. One of the things I see the most, the things people fight over the most, is not usually the investment accounts or the houses, because they're usually just going to sell those and take the cash anyway. It's the items of sentimental value that people fight over the most. Jewelry is the number one most common because oftentimes when people are fighting for those necklaces or earrings or bracelets, they have no intention of selling those things. They specifically want those items because they are status items, one. And number two, they bring the highest amount of connection with the person that gave this to them. Oh, this is my grandfather's ring. Oh, this is my mother's necklace. Oh, this is my aunt's earring. That's something that people really take with them. And as a result, those are the items that get fought over the most. So many times I hear stories of, oh, nobody really wants this earring. I'm going to give this to my oldest daughter. And then I talk with the client 5 months later and it's, oh, all 5 of my daughters are now fighting over this earring. Because they didn't really have that conversation. They just assumed. And then when the conversation really started to happen, it's like, oh, all right, I'm glad we really started this, because if we didn't have this conversation now, this would have been a bloodbath after my passing. And so when it comes to estate planning, there are a lot of things people don't think of, and it is things like that. So it's also important to just have those conversations as well of, all right, I have this Rolex watch. Who wants it? Okay, you're getting this Rolex, but that means you're not getting this ring. So Johnny, you're having this Rolex, but Dave, you're getting this ring. That all sound fair? Perfect. So now, once I pass away, all this stuff has been taken care of, this conversation's been had, and we've made sure everything was equitable. And so really more so than you just having, whether have a trust or a will, it's making sure you have these full estate planning conversations, because these conversations are going to happen. But would you rather them happen with you around to mediate, or would you rather them happen where you've passed away and there's just a battle royale just to figure out who gets what? So I'd like to hear your thoughts in the comments. So if you have any questions, concerns, or if you just like the video, make sure to comment down below. If you like this video, make sure to like and subscribe. If you'd like a complimentary consultation, we offer those as well for anybody who watches this video. Make sure to click the link in the description. Other than that, I'm Tyler Nowotny, and you have a great rest of your day.